Hello everyone, and welcome to this morning's Facebook Live, coming to you on location. So for those that don't know me, my name is Rochelle Manderson and I'm one of the solicitors here at TBA Law and one of the partners. I'll be talking to you today about vendor disclosure in the sale of property. However, if you are thinking of buying a property, do not touch that smartphone, because this is also going to be relevant for you as well. Why? Because if you're purchasing a property, anything the vendor should be disclosing is going to be relevant to you, so you will know what needs to be disclosed. If you are thinking of selling your property or in the process of selling your property, this is going to be extremely important for you to hear some of these things, because there's some information that's relatively, in the grand scheme of the law, relatively recent updates to the law that you may or may not be aware of. So this is going to hopefully be informative for anybody that's looking at buying or selling property or dealing with property in any way. So let's go back to the very simple, very long-standing legal principle that property sale and purchase for so many years has worked by. That is caveat emptor. Caveat emptor is essentially Latin for let the buyer beware. What does that mean? It means that generally speaking, if somebody's buying something, they need to do their own due diligence and they need to take on the responsibility and the liabilities of what they are buying. So obviously there's always laws also coming in about misleading and deceptive conduct, misleading advertising, those sort of things that affects caveat emptor. But caveat emptor is always been a starting position for sale and purchase. So it's up to the purchaser to do their own form of due diligence before they go and put their money down and buy something. However, as always happens, legislation creeps in, because you've got things occurring where suddenly people are finding that there's issues. And how do you solve issues? Well, the law can solve issues, and the law can solve issues by the Parliament legislating against these things. So caveat emptor has been eaten away a little bit and a little bit and a little bit. For decades now, we have had the Section 32 of the Sale of Land Act. Anybody that's had anything to do with property would have to know what I'm talking about here. I'm talking about the vendor statement. I'm talking about the Section 32. This was, I believe it was like early 80s that this legislation was amended, the Sale of Land Act. Section 32, that's where it comes from. It is Section 32 of the Sale of Land Act. It lists a whole heap of things that must be disclosed at the time of sale of the property. So once the potential purchaser finds that they have interest in the property, these things need to be disclosed. And these are disclosed in a vendor statement. There's no pro forma for a vendor statement, but it essentially says the same thing. One of the easiest ways to ensure that everything is disclosed under Section 32 is to rely on your solicitor or your conveyancer to know what they're doing. You would think they would. Now, when you're looking at your vendor statement, there's a few things that must be included. You must make sure that you've got the due diligence page. There's a due diligence page. It's been beautifully prepared by Consumer Affairs. Beautifully done. It has got links all over it. Always make sure that this is in your vendor statement. And generally speaking, you'll find this 2-page document is always somewhere around the vendor statement. There's important information in a vendor statement, and that information is concerning things like like how much are your rates and outgoings on the property. So rates and water. Is there water shares on the property? Things like that. Are there orders against the property? Is there compulsory acquisition coming through against the property, where it might be a large property and there might be compulsory acquisition from Vic Roads because they're putting a freeway in. Those sort of things. These things all need to be disclosed. Is there contaminants in the soil? Is there notices from council or other authorities? Might be regarding something as simple as fencing, anything like that. So these sort of things all need to be in your vendor statement. And when you look through your vendor statement, some people call it the Section 32, some people call it the vendor statement. It's the same document. You look through it and you will see each of these things are listed. Is there? And in many cases, you're going to have not applicable, not applicable, not applicable. there needs to be disclosure of insurance if the insurance is not going to be the responsibility of the vendor to the purchaser. You need to have evidence of vendor finance or terms contract if the property is going to be paid off in installments. So these are the sort of things that you will see in your vendor statement. Your vendor statement is going to have things like, is there services connected to the property? Is it in a bushfire prone area? I know a lot of city slickers are probably not really that concerned about those sort of things. If you're looking for property in the country, you're going to be looking at things like bushfire prone areas, because those areas that are determined require additional safeguards, additional obligations that you need to follow if you live on one of those properties. It might be regarding building. So you'll also need to know what the council zoning is. Council zoning is always disclosed in a vendor statement. And yes, as the purchaser, you would need to then be aware of what you want to use the land for and whether you're allowed to use that property for the purpose that you want to use it. Is that going to clash with the zoning? But the zoning and the overlays will always be there. Heritage overlays are always there. So these are the things that the vendor statement will have, and has had for decades. You will have this information. This is very important. So if you're a seller selling your property, you need to read through this carefully. If you don't understand anything in it, you need to ask your solicitor or ask your conveyancer and say, I don't quite understand what this means, because there's liability here. If you should have disclosed something in the vendor statement and you have not, the purchaser can use that to, prior to settlement, they can use that to get out of the contract. So where you might have what we call an unconditional contract, whereby the purchaser's locked in. If there's an error going on, happening in the vendor statement, or if something hasn't been disclosed, you have got, the purchaser's got this get out of jail free card. They've got a way out. And if you're wanting to sell your property and you are relying on the fact that you've got this contract that's unconditional and that's going to settle on this day and the money's coming in, you might be already directing that elsewhere. You've got these issues to worry about. So this is where you need to understand what's in there, and you need to make sure that it is correct. So when you're looking at a vendor statement, there's a few things that you should see in the attachments. I spoke briefly about the due diligence, as well as what's written in there. The easiest way to make sure that your vendor statement is fully compliant with Section 32 of the Sale of Land Act, is to make sure that it has certain pieces of information, certain information certificates attached to the back. Now, these will be covered when your solicitor or your conveyancer says to you the price is X amount plus disbursements or including disbursements. Some of those disbursements will be the purchase of these information certificates. They are not free. Unfortunately, they're actually quite expensive, and it's quite normal to have at least $200 of disbursements on a very basic vendor statement. If you've got an owner's corporation that needs to be disclosed in a vendor statement, or if you've got a water share through, say, Golden Murray Water in our area, or sufficient understanding this is Facebook, you could be watching this from anywhere, so the rural water company in your area. These are going to be additional, these are going to cost more, so you're looking at, you could be looking at maybe even $600 in disbursements, most of these being these information certificates, but they are very, very important. They are worth paying the money for, and they're not something that you want to try to reduce your costs by not doing. Because, for example, you can get your council information statement from your council. This has every piece of information about council rates and size of property and all those sort of things, capital improved value, all of those things that you need will be on that certificate. It's specifically designed to meet Section 32. Same with your water authority. You get an information statement for your water authority. And this, again, you pay the money for it, but this means that it covers everything that you needed to cover. It covers if there's any easements that may not be registered on title, but you can see through the water. So these things are all very, very important. You will have an information certificate from the State Revenue Office. This tells you if there's any land tax owing. Land tax must be disclosed in the vendor statement. So if there's any land tax that's owing at settlement, you are going to be able to see this in a very simple and straightforward 2-page certificate from the State Revenue Office. You will also see, very often you'll also see a certificate from Vic Roads. Or your relevant, well, this is relevant to Victoria, so it'll be Vic Roads, and it will have if there is any compulsory acquisition, if there's any building permits. You need to include any building permits from the last 7 years need to be disclosed in your vendor statement. So this needs to be obviously disclosed in the body of the vendor statement, but then also this is also included. And again, there are 2 certificates you can get which are really, really easy to get, and you get these again through your local provider, and these will list everything that you need. So it will say if there's been any building permits, it will say that those building permits have been completed. So when you look at that, you can go, right, there was a building permit in 2015, and here's the date it was, and here's the date that it was that the inspection was, and here's the date that it was certified. So you go, right, okay, that work was done, that work was permitted, and it's all above board. So that's good. Now, the interesting thing with building is, up until very recently, there was no requirement to actually disclose building that wasn't constructed under a permit. You only had to disclose the permit. But hold on that, because as of March last year, which is of course March 2020 if you're watching this in the future, things have changed a little bit. So just put that thought to one side just for a moment, and I'll get there. Okay, so these are all the things that you're going to see. You're also going to see a couple of planning permits in there, or not planning permits, sorry, planning information, and this will have what your council has classified the land as. So it's going to have what it's going to have, I don't know, it's rural residential land, and it's going to have, if there's an overlay, there might be a flooding overlay, there might be a heritage overlay, and you're going to see that. Now, if you're able to get an electronic version of this vendor statement, very often, depending on how savvy your solicitor or conveyancer is, very often you'll be able to control click, and that will take you to quite a long page document that you can read, that explains what is a rural residential property, and what can and can't you do. You can't have more than 2 dogs and 2 cats, and you can't operate a brothel, and you can't blah 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 blah. It has all of these things. What do you need a permit for? What don't you need a permit for? So it gives you more information. If not, you can get this from the Department of Environment, Land and Water website, DWELP. So you can actually go there yourself and you can look at that as well. But the vendor statement itself will just have that listed as your zoning, your overlays, and anything like that. So you've got that. So from your vendor statement, you can already see that you're being a very descriptive picture of the land. You're looking at how much is it going to cost a year in your rates and your outgoings. How much is it going to cost if you've got an owner's corporation? What are the rules of the owner's corporation? If you've got any land tax owing at settlement that needs to be dealt with, if there's any rates owing at settlement that needs to be dealt with, all of this is in there. You've also got information about zoning. You've got information about utilities that are connected to the property. If there's anything that's not connected to the property, if the property is accessible by road, if the property is in a bushfire prone area. So these are all things that you need to look at. If there's contaminants in the soil, it can also discuss, and this may be more relevant if you're buying a bush property, it can also discuss there's certain laws surrounding how you deal with certain vegetation or noxious vegetation, noxious weeds, these sort of things. These all need to be disclosed as well. So you should be able to look at that and go, okay, there's such and such a type of tree there that's going to need to be dealt with in this sort of way, because if you've got noxious vegetation on your property, you need to deal with it in a certain way, and you need to show the council that you're reducing that amount, and blah blah blah. So that, again, we're not going into that. However, there's legislation surrounding that. So again, if you're looking at a bush property or a rural property, you might want to bring this up with your solicitor or conveyancer if you're concerned, or if you say, look, I have to deal with my property in this sort of a way. I'm a bit concerned. I've got, I don't know, capeweed or something that you're concerned about, and they can assist you with that. So these are some of the things that you can look at when you're looking at your vendor statement, which brings me to the most interesting part of this discussion, and probably the part that you guys are all waiting for, because this is the new stuff. So what I'm talking about has been around, as I say, for decades, and everyone should be quite aware of it, although you'd be surprised some people are not. As of March 2020, there was a Sale of Land Amendment Act, I believe it was called, came into effect, which changed a few things. It changed things like sunset clauses for buying off the plan. It changed things like auctions on Anzac Day, things like that. But the main thing that I want to talk to you about today is that it changed the requirements and the obligations of the vendor in their disclosure to a potential purchaser. So what it did was, and this is where you've got the other material facts. You might know it as other material facts. I know at our firm we actually have a specific part in our vendor statement now where we will say, are there other material facts? And you will either see them listed or it will be not applicable. Not every vendor statement will be like that you'll get, because different firms will create their vendor statement in slightly different ways, because as long as the information's there's no specific way it has to be presented. But we do that to make sure that everything is covered off and it's very clear and easy to see. So there was always a requirement for a vendor to not fraudulently mislead a potential purchaser about any material fact that might affect the sale and purchase of their property, that may affect the property, that the purchaser, to induce the purchaser to buy, that the purchaser wouldn't otherwise have bought. So that's always been there. But of course, those that are a little bit legal savvy probably know that fraudulent usually requires actual active behaviours. So you have to do something. So this has now been reduced. It is now that you need to disclose any material fact knowingly, not fraudulently. So knowingly means that you only need to know about it. This is a bit more passive. So if you know about it and you don't disclose it, you can now be in breach of the requirements of disclosure in your vendor statement. Some of the examples, and of course this is new legislation when it comes to the law. It's only been around a bit over a year, so there's not a lot of case law on it. There's still discussion on it. But generally speaking, things like if there's been a serious violent crime committed at the premises, that's going to need to be disclosed. If there's been methamphetamines being produced or other illicit drugs and the like being produced somewhere in the property, that's going to need to be disclosed. If there is asbestos in the property, that's going to need to be disclosed. If there is flammable cladding, this is a bit of a hot topic, but flammable cladding, and there's specific types of cladding that is can be combustible or can be more flammable if there's a fire, and in these situations they need to be disclosed as well. Now, I mean, flammable cladding is a bit of a, I think as a description it's a little bit misleading, because it's sort of, flammable or combustible cladding kind of suggests that the cladding can just spontaneously erupt into flames and burn your house down. No, that's not what it is, but it has that lower threshold to fire. And this was made most recently was in the news. Probably a couple of years ago now it was in the news. There was the issues with the high-rise apartments in Melbourne, and there was flammable cladding, and there was the buildings were burning because this wasn't as fire resistant and was more flammable. So this is where this has come from as well. So if you've got one of those types of cladding, off the top of my head, I cannot recall exactly what the type of cladding is, because they don't have normal, easy to remember names. It's got a letter and a number and another letter or something like that. But if you, a quick Google search will tell you what flammable cladding is and what the brands are. And if you're concerned that you have this, you need to disclose that sort of thing in your vendor statement. Any latent defects being defects that you cannot see. So if you can walk into the premises and it is very obvious that there is a broken window, you can see that. You can absolutely see that. So anybody with two eyes should be able to walk into a property when they're doing their inspection and look, there's a broken window. But say, for example, there might be stumps rotted out, or there might be termite infestations in the walls. You won't necessarily be able to see that when you walk through the house and the potential purchaser does their inspection. So this is something that you need to also be aware of, what cannot be seen that could affect somebody's decision to buy or to not buy a property is a material fact, and it will need to be disclosed. So that's as of March 2020. And so that's also a bit of a hot topic that we're keeping an eye on as to how this develops as time goes on. So this is probably the most important takeaway from my presentation for you today, is that this is new legislation that has come in and that has now been in for just over a year, and that you need to be aware of it. Consequences of not disclosing. Obviously, I've already discussed the purchaser can rescind the contract without default before settlement if there's been a lack of disclosure that legislation has required them to disclose. This can happen, so this is important because this can affect a lot of your plans as a vendor. So you've got that. You've also got the risk of lack of disclosure. You've also got the risk of being a civil action against you for misleading conduct or some such if you have knowingly not disclosed what you need to disclose. And this is where you can get a little bit around the caveat emptor being whittled down a little bit. And then there's also with the knowingly not disclosing material facts, it can be up to $20,000 or 5 years in prison. So it's really serious. It's really serious stuff, and it's something that you want to make sure that you're on top of, and it's something that you want to make sure that you do, and something that you want to make sure that you're talking to your solicitor or your conveyancer about, because, as I say, you're talking some serious consequences. You're talking some serious money here, and whenever you're looking at a sale and purchase of property, you are talking about hundreds of thousands of dollars. So when you're talking about hundreds of thousands of dollars, the last thing you want to be doing as a vendor is going, oh, look, I can get my vendor statement and conveyance completed for $600. I'm going to go there because they're the cheapest. I'm not going to go to the place that's charging, $1,200 or $1,000 plus disbursements or whatever the charge might be. Because if they're trying to compete by having an extremely low price, there's a good chance some of the things that they are going to be cutting their price on is purchase and inclusion of the information certificates. So you're going to risk non-disclosure in your vendor statement, which at best nothing happens, but at best, if it's an issue, your settlement could fall over and you have to go through the whole process again, which could have financial implications for you and your plans. At worst, you're looking at up to $20,000 fine. You're looking at prison. So if you are really looking at sale and purchase of land, speaking here specifically sale of land, understand the importance of these legal documents and understand that it does cost money in disbursements to get these information certificates, but these information certificates are specifically designed to ensure that Section 32 is covered. and your disclosure obligations are covered. So when you're looking at that, perhaps looking to cut your costs by cutting your legal fees may not be the best option for you, because it's incredibly important that these are included and that your solicitor or your conveyancer knows what they are doing. So essentially, I suppose that's my other takeaway for you, is to please don't try to cost cut on your vendor statement or on your legal fees by going with the cheapest possible rate or not having these things included, because these things, although they cost money, they might seem like dead money to you at the time. Why am I spending $500-600 on all these certificates? Why do I need a certificate from Vic Road saying that there's no compulsory acquisition, no freeway is going to go through my property? Why do I need, state revenue office saying nothing's owing? It's because of the legislation, and it's because it's required to be disclosed. And why do I need somebody that that's experienced in this sort of thing, that's going to understand and keep up with these new pieces of legislation that's coming in, these new amendments? You need it because you need to have somebody that understands what's required to be disclosed, what's a material fact, and how is it going to keep you out of proverbial hot water if it all hits the fan. And believe me, it can all hit the fan no matter what your best intentions are. So please keep this in mind when you are looking to sell property, and also keep this in mind if you're looking to buy property, because these are the sort of things that you're going to be looking at. So this video will be here for you on our page for you to have a look at any point in time in the future. You can find it here on our Facebook page. You can find it on our website, tbalaw.com.au, and you can also find some really interesting blogs by both myself and some of our other colleagues on buying and selling property. And of course, there's nothing quite like actually speaking to your legal representative if you're going through this process, and just knowing the questions to ask. You can also find out some really good information on the Consumer Affairs website. Don't believe everything you find on Google, but websites such as Consumer Affairs or DWELP, those sort of websites are you're pretty safe on those. Even like Law Institute of Victoria, those sort of things, you might find some good blogs on there as well. So thank you for listening to me today. I hope you're enjoying this beautiful first day out of lockdown if you're in Metro, and well, if you're in regional, you're out of lockdown anyway, but first day of having 2 visitors to your house. If you're in regional, enjoy this beautiful day, even if the sun isn't shining. And if you've got any questions, please feel free to call your solicitor, your conveyancer, rewatch this video, and I wish you a beautiful day. Thanks for watching, and bye-bye.